My name is Christy Jeffries, and I'm a tax manager here at Dermody, Burke Brown. As many are aware, on March 27th, President Trump signed into law the Coronavirus Aid, Relief, and Economic Security Act, referred to as the CARES Act. Today I'm going to highlight some of the individual provisions that are provided in this act. The first provision that I would like to discuss is the recovery rebate that will be available to individual taxpayers. This is a one-time payment of up to $1,200 for individual filers or $2,400 for joint filers, with an additional $500 for each qualifying dependent that you have under the age of 17. It is important to note that individual filers will be phased out when their AGI hits, or adjusted gross income, hits $75,000 up to $99,000, and joint filers will be phased out when their adjusted gross income ranges between $150,000 to $198,000. This payment will be paid in the form of physical checks or through direct deposit. The IRS will calculate the amount of payment that you are due based on your 2019 tax return as filed. If you have not filed a 2019 tax return yet, it will be based on your 2018 tax return. If no return was filed for these years, the IRS will look to Social Security statements to determine the amount of payment that an individual is eligible for. The second provision provides for a $600 increase in unemployment compensation benefits. In addition, it increases the eligibility range from 26 weeks to 39 weeks. It is important to note that this also applies to self-employed individuals as well as independent contractors such as gig economy employees like Uber drivers. The third provision allows for a $300 above-the-line charitable contribution deduction. This effectively allows individuals who make charitable contributions but are otherwise taking the standard deduction to get a benefit from a charitable contribution deduction in 2020. The fourth provision includes an exclusion for employer payments of student loan debt. Currently, individuals are eligible to exclude up to $5,250 from income for payments received by employers for educational assistance programs. The CARES Act expands the definition of types of payments that qualify under these programs to include payments of student loan debt made before January 1st, 2021. The fifth provision allows a break for remote care services paid for under a high deductible plan. For plan years beginning before 2021, the CARES Act allows for high deductible plans to pay for remote care services and remote health services without regard to the deductible amount for the plan. The sixth provision allows for a break for non-prescription medical care paid for under certain medical savings accounts. For payments made after December 31st, 2019, the CARES Act allows payments made from an HSA or a health savings account and an Archer medical savings account to be treated as paid for medical care even if they were not paid under a prescription. For reimbursements after December 31st, 2019, similar rules apply to flexible spending arrangements and health reimbursement arrangements. The seventh and final provision that I'm going to discuss relates to student loan repayment. Federal payments of student loan debt and interest accrual have been suspended through September 30th, 2020. This means that any payment that was suspended will be treated as if on-time payment was made for federal loan forgiveness purposes. In addition, any involuntary collections related to student loans have been suspended as well. This includes wage garnishments, reduction of tax refunds, and negative credit reporting. If you have any questions about the information that has been presented here today, please do not hesitate to reach out to your Dermody, Burke & Brown advisor to discuss further.